finally time for the prime time debate. Now, the Supreme Court criminalized sex between a man and his underage wife, a landmark ruling that fixes the age of consent at 18. Well, Section 375 of the Indian Penal Code says that sex with a girl who's below 18 is rape, but it had an exception which allowed a man to have sex with his underage wife, 15 or above, even without her consent, which the Supreme Court criminalized today. To discuss the implications of this judgment, we're joined by the petitioner, Vikram Srivastava. He's the founder of the Independent Thought, that's an NGO, and Indira Jaising, who is an advocate at the Supreme Court, of course, and she's also the first woman Additional Solicitor General of India. She was the first woman Additional Solicitor General of India. Ms. Jaising, I'd like to start by asking you, on the previous show we were having a quick conversation with Mr. Tulsi, and he seemed to be of the view that, well, this exception should not have been done away with because it's a protection which in some cases is justified. I want to understand from you what your take is on this whole situation and how have you responded to this particular ruling? Ms. Jaising, so I'd like to start by asking you whether you think, well, this ruling is it's a landmark ruling in all aspects, but do you think that this is enough when it comes to the problem of perhaps child marriage in India, or is that the next logical step in this situation?
Is that a question to me?
Yes, Ms. Jaising, I'm starting off with you.
Yes, okay. So, as you know, the interesting thing about this judgment is that it's very much a judgment about child marriage. And in answer to your direct question, I would say it's certainly not enough. Unless and until child marriages are declared void, even though the Supreme Court says that for a husband to have sex with his wife who's between the ages of 15 and 18 is an offense of rape, the fact of the matter is that he will have unrestricted access to her. And there is no knowing what he is going to do behind closed doors. Hence, the real solution to the problem is to say that a child marriage is null and void, so that a man cannot have access to a woman who's below 18 in a relationship of marriage. So no, it's not enough. We need to go a lot more further.
Right, Ms. Jaising, because it's interesting that you said that, because I was on the previous show, we were having a conversation with KTS Tulsi, and he seemed to suggest that, well, he was against what happened in this case particularly, because he thought that this exception should be on the statute books in order to protect, well, men who are perhaps wrongly framed or are innocent in some, or who have some sort of defense in the law.
I can't hear you.
No, okay. What I'll do is, Ms. Jaising. No, so we also have the petitioner in the case, Mr. Srivastava. Mr. Srivastava, thanks so much for speaking with us to Bloomberg Quint. I'd also like to ask you. This was a petition that you filed in 2013. It's been 4 years. Do you think that this was? I mean, is this what you expected? Is this what you had? What you'd written down in the petition? Because I'd like to ask you whether this is, well, how are you actually viewing this judgment?
See, we placed a very limited plea in the petition, and we used a very legal argument of POCSO and JJ Act, which kind of freezes the age of children as 18 years. And POCSO brought two very essential legal concepts. One is that the age of consent was made to 18 universally. Second, it didn't have any exceptions as such. In fact, in certain relationships, it made the offense more aggravated. So we used those provisions which were in direct conflict with the exception, and then filed a petition seeking declaration as unconstitutional.
Right, Mr. Srivastava, but you know, in terms of, well, if you look at the other legislations, it's kind of, the age of consent seemed to be 18 in all other legislations, be it, well, the ones that you actually spoke about. And, well, you also, obviously, it was in terms of Article 14 that this judgment was actually meted out. Ms. Jaising, if you could hear me now, what I was trying to ask you earlier was that was this, well, a case of too little too late, considering that, well, other legislations have caught up when it comes to the age of consent. And also, we were speaking to KTS Tulsi earlier, and he seemed to be of the opinion that, well, this exception, that's exception 2 to section 375, should have remained on the statute books, considering it's a legitimate defense for someone who's innocent.
Is that a question to me?
Yes, Ms. Jaising, that's a question to you.
Okay. To the extent that the court has tried to harmonize several laws, including POCSO, the Indian Penal Code, the Juvenile Justice Act, on the question who is a child, I think, yes, it's a progressive judgment. You know, the problem, however, is that, and the court recognizes that in its observations throughout the judgment. In fact, one of the judges, Justice Deepak Gupta, says that it's really a bit hypocritical to say that a child marriage is voidable and not void. You don't expect a 15-year-old to go to court and say that I want my marriage declared void. And he goes to the extent of saying, wondering whether the Union of India is just paying lip sympathy to the fact that child marriage is to be abolished. And so there's a clear recognition of the fact that it is necessary in law that all child marriages be declared void. However, that was not the issue before the court, and that is the reason why, when you asked me a question whether there is a need to go forward, there is a need for the legislature, for parliament, for government to go forward. The court has gone far, far, far enough. One cannot expect more than this from the court, and I would repeat and say this is a highly progressive judgment. But you must understand that this is a judgment which focuses on the rights of a child, and in particular the girl child. What the court is telling us is that a husband must not have sexual access to a girl child who is married to him between the ages of 15 and 18. And that is why I say, yes, the judgment is excellent. It also harmonizes with POCSO, but because the court says there's no difference between rape and aggravated sexual assault, penetrative assault, which is all true. But the real question is this going to stop child marriage in this country? So right now what you have is a situation in which you can be married between the age of 15 and 18, but there can be no sex in that marriage. So obviously we will all want to know, why should a marriage of this kind not be declared void?
Right, Ms. Jaising, I know that it's not, well, directly connected to the other case. And just as a last follow-up question, and also this was something that, you know, Mr. Srivastava was saying. Mr. Srivastava, you were mentioning earlier that you would hope that this judgment would really percolate down to the villages where this evil of child marriage actually exists.
See, there's a shift in the way the earlier protection was. Till yesterday, any man who wanted to marry a minor was protected by this exception. Now that exception has been blown off. Now anyone who wants to marry and thinks of marrying a minor will always have to think about the repercussions, which can be as grave as charges of rape. And so when the messages go across the country, there will be both child marriages and also in the shift in the mindset of the people.
Right, you know, as a last question to Ms. Jaising, if you're still on the line, Ms. Jaising, I just want to ask you, will this have any sort of implications for the marital rape case which is pending before the Delhi High Court?
Yeah. See, before I answer that question, I want to raise an issue on the age of consent itself. Now, you know, you must know this, that when the 2013 law was being drafted, the women's movement actually opposed the increasing of the age of consent for 15 to 18. Forget about married women, let's say even for non-married women, okay? What the women's movement was arguing is that you can have consensual sexual activity between adolescents. 15 to 18 is considered the age of adolescence. And we all know that this is an age at which people between 15 and 18 experiment with their sexuality. Now, to criminalize that activity is not something that the women's movement wanted. So what I would like to say is, let us separate the issue of child marriage from the issue of sexual activity between the age of 15 and 18. I would completely oppose child marriage, okay, below the age of 18, because of the reasons that the court sets out. It's not good for your reproductive health, it's not good for your mental, emotional, physical health. Therefore, child marriage has to go. But on the other hand, I think consensual sexual activity between non-married persons between the age of 15 and 18 should not be criminalized. What we are doing is we are creating an army of adolescent criminals in this country who may be having sex with each other with consent. And so I think there is really a need to look at the whole issue of age of consent independently of the issue of age of marriage. Age of marriage should remain at 18, I agree. But it doesn't follow from that the age of consent should also be 18. On your question of marital rape, yes, it's a bigger issue. It's a different issue. The court repeatedly says that we do not go into that. But some of the observations in the judgment which relate to the centrality of consent, the centrality of discrimination, would apply equally to the issue of marital rape. So a woman can well argue, why should there be discrimination between a married and a non-married woman when it comes to the issue of consent? We have to wait and see what the Delhi High Court is going to say about it. But I think the Delhi High Court will take its decision independently of this decision, no doubt keeping this in mind.
Right, Ms. Jaising, thanks so much for speaking with us at Bloomberg Quinn. Mr. Srivastava too, thank you for talking to us. And all of you tuned in, thanks so much for tuning in to Prime Time Debate.